Tony, do you want to swap over so you're closest? Otherwise you've got to walk below. You can see my left. I'll keep that.
Okay, fine. Just because this is new.
Get it, Simon.
That's right. It's all right. I'll join the hot spring.
Is the court ready?
All right, is available.
Miss MacDonald, I apologise if we've kept you waiting, but I think that clock is a little bit fast, so we're not as naughty as we appear.
No, I'm conscious. It's certainly going by my watch. It's a couple of minutes ahead.
Yes. In any event, please could you keep your voice up, because it's particularly difficult, or will be, for Lord Justice Arnold on that side with the noise in the street.
Yes. To start, just to return to a question that my Lord Justice Phillips asked before lunch, the fundamental question of why are we talking about English law here? And I said rather inarticulately that it was because English law was the law of the contract. That's correct, but to unpack that reason just a little bit so that we understand it. And we have this from Bosted, chapter 12, paragraph 17. It's because the relevant law here is the law that governs the relationship between the ratifying principal, or the supposedly ratifying principal, and the third party. So here, it is the contract. So it's the relevant debt instruments, and that shorthand was therefore why I said it's because that's governed by English law. So it's the law. If that contract had said it was governed by French law, then that would have been a question. If it said it was governed by Cuban law, then it would be a question of Cuban law. So it's the law of the contract because that's the law as between the principal and the third party. So just to help to give a slightly, to unpack my shorthand from before the lunch break. So I said there were 4 points that we make on ratification. First point is the judge's conclusions on the role of the Central Bank of Cuba and the role that it played in the preparation of BNC's responses to the letters before action. We've seen, but not yet looked at the judge's factual findings in the subparagraphs at paragraph 348 of her judgment. If I can invite the court to turn that up, that's core bundle, tab 8, and bundle page numbering 152. And we see halfway down, we start at 348, and she reaches a total of 11. We don't need to look at them all, but a total of 11 points in small Roman numerals before she reaches the conclusions that we looked at before the adjournment. Now, the relevant findings for this part of the argument are paragraphs 1 to 4. We see that 1 and 2, I won't read them out, but ask the court to read them to themselves. 1 and 2. And then looking for a moment at 3, she moves on then to say that the involvement of representatives from the Central Bank of Cuba in the working group that was convened to respond to CRF's letters before action was, in her words, significant, and that the working group involved, in her words, an extensive list of serious senior people. And if we go over the page, the involvement of this list of senior people leads in part, it seems, to her conclusion at subparagraph 4 that the working group reviewed certain documents. And I'll come back to paragraph 4 shortly when we look at my second point on this ground of appeal. So I skip over the details of point 4 for now, because that will be my second argument on the ratification ground of appeal. And where this goes, tracing through the role, in her view, of the Central Bank of Cuba, this flows through to 349 that we looked at before lunch, where we can see that she attaches significance to the involvement of representatives from the central bank, and she indeed notes her conclusion that BNC reviewed and signed responses to the letters before action with the consent of the Central Bank of Cuba. So she clearly found it important on this issue.
Well, what relevance does it have? I mean, was it your case that the consent of the Central Bank of Cuba was required?
No.
In which case, why does it matter?
Well, on our... well, perhaps if I can trace through how it arose, and then we see what significance. It was not significant on BNC's case at all. It was extremely significant on CRF's case, going to what they said to be, and I won't make CRF's case for it, but going to what they said was full knowledge of all the material circumstances by those ratifying.
But if they had ratification by BNC, then Central Bank of Cuba adds nothing. And if you weren't saying that the consent of the Central Bank of Cuba was required, then it seems to be a complete non-issue.
Well, on that analysis, yes, it would be a red herring. It was common ground that this wasn't pleaded. The role of the central bank was not pleaded by CRF.
Something may be part of the facts without being relevant for the purposes of the issue to be decided. So if you're finding who attended a meeting and it is a fact that representatives of entity X attended, then you find that fact. It doesn't mean to say that that's depositive as any issue, because the involvement of party X may be completely neutral. It doesn't mean it's wrong to find the fact, does it?
My lord, no. We said, to take it in stages, it wasn't pleaded. CRF, and of course they will develop this now, placed in terms of cross-examination of the witnesses at trial, some emphasis on it. The judge, we of course say the question is, did BNC, Mr. Fernandez, and those who assisted him in preparing the response have full knowledge of all the relevant circumstances? We see the judge, and that's what I just sought to trace through for the court, we see the judge placing significant weight, it seems, on what she says was the involvement of senior people and the serious group of senior people,
All right,
etc.
sorry, maybe I'm not being clear enough. Take paragraph 349 of the judgment. First sentence, but there is only one sentence. But take the first and second lines. Take the words, and the consent of the Central Bank of Cuba. You can strike through those words, and the finding still holds good, and it makes no difference or not to the question of whether, that I raised earlier, of whether 350 follows from it or not. Your case against the conclusion on 350 is equally strong, whether those words are present or not. But equally, if they do follow, then the presence of those words is completely immaterial. It seems to me you're shooting at a target that makes no sense when you've got better targets to shoot at.
Well, I'm entirely content to shoot it. We set out our points on this in our skeleton arguments. And
The relevance of it. If you can tell me the relevance of it, then go ahead.
But
at the moment, you've told me it's irrelevant.
In our submission, it is. It seemed to us on a reading of the judgment that to the judge it was significant. And if it was significant to her reasoning, we were, and your lordship is there already, we were seeking to persuade the court that it was not. She does seem to have attached some significance to it in her analysis. There was significant time devoted, we have the relevant portions of the transcript, by CRF to putting to BNC's witnesses that the central bank had been involved in some way in the working group. But as my Lord Justice Arnold indicates, of course, the relevant knowledge was the question of what BNC was intending to do and what they knew. And that forms our second criticism. If I can move on to that, we've disposed of the central bank relatively quickly, subject, of course, to I'll respond to anything that's said on this topic and that needs any further response by CRF. We'll respond at reply stage. But if we then go ahead to the second point we make on the ratification issue, this goes to the judge's findings, and this goes right to the heart of the matter, the judge's findings on the extent to which those in BNC who were involved in assisting with the preparation of Mr. Fernandez's letters had reviewed the underlying documentation relating to the assignment process. We address this in our skeleton starting at paragraph 26. Now, the court will have seen, and of course it featured in the discussion with Mr. Dudnikoff this morning, the court will have seen from the judgment that the judge found that the key document by which prior consent had been given was an email, the email from Ms. Marty of the 13th of June 2019. And as we've already seen before lunch, the issue of full knowledge of the material circumstances in which the act was done, central to the question of ratification, as the judge correctly found. And on the judge's analysis, the 13th of June email was the key act in the assignment process, which makes it central to the ratification analysis. In other words, this was the unauthorized, on BNC's case, this was the unauthorized act that had to be ratified. Now, the judge looked at this at paragraph 3484, if the court would take the judgment up again. This is at tab 8, bundle numbering 153. We see the long paragraph starting unsurprisingly. And may I invite the court to read that paragraph, in particular from the hotly contested issue onwards. So we can see from this that in reaching the conclusion she does, the judge rejects the evidence of each of the defendant's witnesses who addressed the preparation of these two letters, both in their witness statements and orally at trial. Now, the defendants, I won't trawl us through the transcripts. The defendants have collated and summarised the relevant evidence at paragraph 27 of our skeleton. There are short extracts from the transcripts in the bundles to summarise very briefly who the witnesses were and what they said. Firstly, the evidence of Mr. Fernandez himself, obviously important on this issue, was that he said in his witness statement, and again, I take this quickly for the court's notes that all the relevant references are in the skeleton, paragraph 27. He says in his witness statement that he didn't read any documents relating to the assignment, didn't conduct any analysis. Says similar in relation to the preparation of the second letter. And in his oral evidence, and again we have all the transcript references in our skeleton, he says that when the reply was prepared, the validity or not of the assignment was not assessed by anybody. We have secondly the evidence of Ms. Zubeldia, who was BNC's legal director. She gave evidence to similar effect. In cross-examination, she repeatedly explained that Mr. Fernandez's letters were only concerned with stating that payment of the debts was not economically possible because of the situation in the country, and the court's seen before the adjournment, the court saw the points that were being made there about the economic situation of the country. She said, Ms. Zubeldia, the legal director, said that the working group that he convened didn't at that time review the documents relating to the underlying assignment. She went on to say that if they had reviewed the underlying documents, then logically, she said, we would have responded to the letters differently. It would have been even easier for us to say that the assignment wasn't valid, and therefore that would have finalised the whole exchange of communication, but we didn't know at that point in time. Thirdly, we have Mr. Lozano, a director of operations at BNC, who the evidence was the one who drafted the letters sent by Mr. Fernandez. He said he didn't inform Mr. Fernandez of all the circumstances. His evidence was that the group formed by Mr. Fernandez to respond to the letters, and Mr. Fernandez personally, didn't review the documents in the debt assignment file when preparing the response, but only after a later date, after the claim had been commenced, and they went back to look in more detail at it. And finally, we had the evidence of Ms. Rio Alvarez, BNC's current president since February 2021, then vice president, who likewise explained that in preparing the response, they did not review the underlying file.
But the judge didn't believe them. Can we go behind that?
Well, my lord, it's said against us by CRF, well, this is an attack on the findings of fact by a judge who saw the witnesses and preferred some other evidence. In our submission, though, one can, and the reason I say that is for the very specific reason that the evidence that she preferred was the hearsay evidence of Ms. Marty, and there's a number of criticisms that we would outline in relation to that. So we say, in answer to my Lord Justice Arnold's question, and I will, I hope, develop this in the next few moments, we say yes, because it's not a classic situation. We're not saying she preferred live witness A over live witness B. Now, that's a classic situation where it would be very difficult to persuade this court to reach a different view. The complaint that we have, and I hope I'll make good, is that she preferred hearsay evidence, which we can look at in a moment, didn't, in fact, assist her to reach the factual conclusion that she reached. So we say it's not a question of asking this court to reweigh the evidence of different live witnesses who the trial judge had the advantage of hearing from. She preferred, and we see it subparagraph 4, she preferred the evidence of Ms. Marty. There are some initial procedural criticisms that we make of that. Firstly, it was hearsay in respect of which no notice had been served, as required by, of course, the Civil Evidence Act, the CPR, and the CMC order of Mr. Justice Andrew Baker. So the procedural formalities had not been gone through. CRF says in response to that...
What's the consequence of that? There must be some learning on what the consequence is if you fail to serve a notice.
But CRF says that I think both parties say it goes to wait.
Goes to wait.
Goes to wait.
Does go to wait.
It goes to wait, and she gave it in this case, and this is why we say, and we don't, of course, lightly advance the ground which involves some live witness evidence. We understand that it's difficult to bring that kind of thing before this court, but we say the circumstances are rather unusual here, where there were, on the one hand, all the live witnesses. On the other hand, there was a piece of hearsay evidence whose weight had to be reduced, we say, because of, firstly, the non-compliance with the procedural formalities. Secondly, because it hadn't been put, her evidence was not put to Mr. Fernandez. So he wasn't asked what he said about what she'd said at trial, her trial in Havana.
And what about the other three witnesses? Was it put to them?
It was put, yes, it was put. The only witness to whom the hearsay evidence of Ms. Marty was put was Ms. Rio Alvarez. She was asked about it, and the reference is Supplementary Bundle, tab 27, page 121. She was asked about it and said, we can turn it up if it's of assistance, but in summary she said, well, that wasn't her view of events, and that she didn't, they didn't review any underlying documentation.
What about Mr. Lozano and Ms. Zubeldia?
No.
No.
No. Ms. Rio Alvarez solely, so not Mr. Fernandez or the other two witnesses who gave evidence on this topic. And I'm going to ask the court in a moment to look at the hearsay evidence. It's one page from the Cuban Cuban criminal trial transcript to make good the submission I'm about to make. But there's one small point on the question of weight, where I think CRF make a criticism which I think goes to the issue of weight and will be sensibly dealt with here. They refer at paragraph 49 of the skeleton to what they describe as, I quote, the fact that Ms. Marty was available to be but was not called by BNC to give evidence at the trial. So I think the implication is that BNC chose not to call a willing witness. But we know that the judge recorded at paragraph 201 of the judgment, that's at page 120 of the bundle numbering. And the judge records at paragraph 201, page 120, she says, Ms. Marty would have plainly been a highly relevant witness, but towards the bottom of the paragraph, she says, however, I am told on this by our solicitor's letter that Ms. Marty was approached on more than one occasion but did not agree to give evidence in these proceedings. So if the implication by CRF is that Ms. Marty's absence could or should in some way be held against BNC or go to the weight of her hearsay evidence, then we would resist that. And indeed, that didn't form any part of the judge's reasoning as we read it.
Well, it might go to your first point about hearsay notice, because what that indicates is that service of the hearsay notice would have made no difference because she wasn't going to cooperate anyway.
Yes, we accept that.
Right.
So we accept that it seems that she wasn't going to cooperate, so the point is simply to submit that it shouldn't be held against, her absence should not be held against BNC.
But she's not in your employ anymore.
Yes, precisely. So we're responding to the criticism, whatever it might be, by CRF, who seek to place some weight on what they say is the fact that she was available.
When you say yes,
to...
yes, she is still employed, or yes, she isn't still employed.
No, she is. Oh, sorry, it's a factual question. No, she's not. She was dismissed.
Yes. So it was just as open to CRF to call her as it was to you.
I mean, one anticipates, of course one can't speak, one anticipates that she would not have been any more willing to be involved when requested by them than when requested by BNC.
But fancy the force of a, I'm saying, fancy the force of an argument that it should be taken against you that you didn't call her when it would have been open to CRF to call her.
Well,
she's not employed by you anymore, so you have no power over her. She's not employed by you, so they could have called her.
my Lord makes exactly the argument that we seek to make in response to that criticism by CRF.
Yes. Well, it seems to be the end of the point, isn't it?
So, if we look at what Ms. Marty actually said at trial, I'd invite the court to look. This is in the supplementary bundle at tab 34, page 156. And before I invite the court to look at what's said there, the context of this, of course, is the judge's finding at her subparagraph 4, that I invited the court to read a few moments ago, that, and she noted the hotly contested, this was the hotly contested issue, as she described it, was whether the review extended beyond the underlying loan documentation and the letter of 25th of November and into the wider assignment documents, including the letter, I think by that she means email, of 13th of June. And if we pause there, of course, a review of the wider assignment documents and, of course, the email of the 13th of June would have had to have taken place in order, we say, to permit a conclusion that Mr. Fernandez signed his letters with full knowledge of the surrounding circumstances within the meaning of the case law that we've seen on ratification. And then we look at the judge in subparagraph 4 that we've seen, where she says, here I conclude that Ms. Marty's evidence in the Cuban criminal proceedings is to be preferred to the denials of the witnesses called in these proceedings. And she cites, again, I appreciate the court's got a different bundle open in front of it, but if you recall what Ms. Marty is quoted by the judge as saying in the subparagraph 4, the quote is, and we'll look at the full thing in a moment, Raul sent me, that is Mr. Oliveira Lozano, Raul sent me to ask for the originals of the deposit agreements from the Italian Banking Institute and Credit Lyonnais in Holland. He asked me for the documentation, and then the judge also quotes the words, we checked, everybody checked the documents. Now, if we look at the transcript, so this is the tab 34 in the supplementary bundle, we see what's said. It's very short. We have answer at the top of the page. This is Ms. Marty speaking. Of course, this is all in translation. The agreements, yes, Raul, that's Mr. Lozano, sent me to ask for the originals of the deposit agreements from the Italian Banking Institute and Credit Lyonnais in Holland. He asked me for the documentation. There's a few questions which are irrelevant. And then the judge quotes at line 9, we checked, everybody checked the documents. Question the agreements. When you tell me the documents, what are you referring to? And she says, to the original agreements of the Banking Institute, plus that of Credit Agricole, yes, Credit Lyonnais of the Netherlands. Did you see them? We reviewed them between Maria Teresa, myself, Raul. It was reviewed. So that's the sum total of the hearsay evidence that the judge preferred on this point to the live witnesses. And that's the factual foundation for her conclusion that they must have looked at the full files, including the underlying documents going to the assignment process. Now, there's no mention here of anybody having looked at anything beyond the basic loan agreements, the IBI and Credit Lyonnais loan agreements, let alone the email of 13th of June. And even though the 13th of June email was, on the judge's findings, the critical document, since that was the unauthorised act, which was supposedly ratified by Mr. Fernandez in his letters. So, to round off on this point, of course we accept that as a matter of principle, in the normal run of things, the assessment of witness evidence is primarily for the trial judge. So here, we take a number of factors together. The judge preferred evidence over the consistent evidence of all of the live witnesses in the trial. She preferred evidence which was hearsay, not the subject of a notice, not put to Mr. Fernandez, who signed the letters, and which crucially, even if one ignores the lack of a notice, the other procedural criticisms, which crucially in its contents, and here this court, we say respectfully, is in just as good a position to read the transcript of the Cuban legal proceedings as was the trial judge. So on this topic, she doesn't enjoy didn't enjoy a special benefit as the judge who was sitting in the trial, we say the evidence on its face doesn't substantiate the conclusion that she sought to draw from it, namely that the review process before the letters were sent encompassed anything beyond the bare agreements, the old-looking typed documents from 1984 that Ms. Marty describes having looked out at the request of Mr. Lozano. So there's no suggestion from her that they got out the full file and checked about 2019.
But isn't what the judge doing here is she's looking at Mr. Fernandez's broad assertion that he didn't read any documents relating to the assignments and didn't conduct any analysis. And I think what she's relying on Ms. Marty's evidence for is the part that where she said expressly that she reviewed documentation with Raoul. And so that's what she relies upon to find, in part, what she relies upon to find that Mr. Fernandez's evidence wasn't credible.
It seems to be the process of reasoning, and we say it's a jump on this transcript. We say it's a considerable jump to say, when she starts by saying, Raoul sent me to ask for the originals of the deposit agreements, he asked me for the documentation, everybody checked the documents, and then she says again at line 12, to the original agreements of the Banking Institute plus that of Credit Agricole, yes, Credit Lyonnais of the Netherlands. So again, she's asked twice what the documents were, and on neither occasion does she go beyond saying they were the original all-type documents from 1984. And again, there's no reference here to Mr. Fernandez at all.
But the judge does go on at subparagraph 5 to consider the 13th of June email separately, in the sense of whether or not the 13th of June email was itself checked, etc., etc. So it's not that she's necessarily lumping the that email in her conclusions at little 4.
The phrase that Milady has just drawn attention to forms, in fact, the third criticism that we have of this part of the reasoning. Because
so let me take you out.
You
do what you want.
No, of course. To take it in stages, it appears that the judge takes from the transcript that we've looked at from Ms. Marty, her evidence given in Cuba, draws from that, as the judge put it, the review, in other words, the process that led up to writing and drafting the letters in response to Gibson Dunn, that the review, her view, was that it extended beyond the underlying loan documentation into the wider assignment documents, including the letter of 13th of June. So she concludes, on my reading, certainly at paragraph 4, that they went far beyond the original 1984 loan documents, although in my submission, when one looks at Ms. Marty's evidence, she doesn't say anything beyond those documents, although she's asked twice. And then, at subparagraph 5, as Milady points out, and this forms our next criticism of the reasoning here, it appears, when she says whether or not the 13th of June email was itself checked, it appears that what she's saying is it wouldn't have been critical whether or not the 13th of June email was checked. And the short point that we make is, since the judge had concluded that that email was the critical document, so that was the unauthorized act that Mr. Fernandez is said to have ratified, and given the test of full knowledge of the material circumstances, we say he couldn't have ratified that email if he'd never seen that email, is the short point. So it was critical that he'd seen that email and its full surrounding context. And it's not clear from the judge, it seems at subparagraph 4, that she concludes that more or less likely he did see the 13th of June email, although Ms. Marty doesn't mention it, but that it wouldn't have been vital that he did. And we take that from whether or not the 13th of June email was itself checked. So in our submission, there's not here any secure factual basis for a conclusion that the necessary unauthorised act, Mr. Fernandez was even aware of the unauthorised act, let alone that he ratified it, because the basis, and it's all documentary in Ms. Marty's hearsay evidence, and contrary to everything that the live witnesses said, the basis, it's too slender a foundation for such an important conclusion.
Is going back to the evidence point, is your point that what your witnesses had dealt with was whether or not was that they had not looked at the documents or the file relating to the assignment, whereas all Miss Marty was dealing with was the fact that she had gone and got the contracts themselves, and the judge seems to have rejected your witnesses' evidence that they didn't look at any documents relating to the assignments, in part on the basis that Miss Marty had said that they had looked at the contracts.
Precisely. There was consensus. There was consensus as between the live witnesses and Ms. Marty's trial transcript that the original loan documents, so the 1984 documents, had been brought up and looked at. But then we get a conclusion in the judgment that the review process went beyond that into the events of 2019, if we can call that as a shorthand, based on said to be based on Ms. Marty's Cuban evidence, but based on no indication as we read it. And here we say the court's in as good a position as the trial judge to read that evidence. No indication by her that what she'd done was go and get the 2019 file and study it or pass it to others for study. So the fourth point that we make on the topic of ratification is slightly different. This relates to the applicability of the pre-action protocol. The court has seen that these letters were sent by BNC in response to pre-action correspondence marked as such from CRF's then solicitors Gibson Dunn, stated openly that it was sent in accordance with the process set out in the practice direction on pre-action conduct and protocols. And paragraph 4 of the pre-action practice direction provides that a pre-action protocol or this practice direction must not be used by a party as a tactical device to secure an unfair advantage over another party. So
I don't get this point, because what's wrong if you write a pre-action letter and you get in response an admission? You're perfectly entitled to rely upon the admission. There's nothing untoward about that. In fact, it happens daily. The problem is, from the respondent's perspective, and surely your better point, is it wasn't an admission. If it had been, there would have been nothing wrong with them relying on it.
Well, taking those 2 points in stages, and I appreciate the first point, that obviously when a party might respond to a pre-action letter, and this would be the pre-action protocol doing a good job and circumventing the need for litigation, a party might respond with a full admission and an offer of damages or whatever was being sought.
But it could be a partial admission.
They may respond in any way that was clearly intended to be binding on them. Points we make in this particular circumstance were, firstly, of course, this was an unrepresented party. It was based abroad. It wasn't English speaking, and we've been looking at letters in English, but of course they were written in Spanish. So we say that in those circumstances, of course, still that unrepresented party located abroad might make some form of binding.
Relevance of that? They could have instructed English solicitors. They chose not to.
Well, I think there's two separate points. An unrepresented party might choose to instruct solicitors, but we have to look at the letters in the context in which they were in fact written. And since in fact these letters were written by an unrepresented party, in my submission, that does mean that the court would look for particularly clear language if what it was saying...
But that's the point, isn't it? The point is there's no admission. There's nothing wrong with the process. It's a simple point of, here's what they said, and is it an omission or is it not?
Yes, and the final point we make on this topic in the skeleton is precisely that after all of this, the words that the judge, and we see them, you see she sets out, and this is 348 subparagraph 8. So this is core bundle tab 8, page 153. And if I can invite the court to look at the italicized terms in subparagraphs 8 and 10, these are the words, and we flagged them up when I drew the letters to the court's attention before lunch. These are the words in italics that the judge sees as amounting to a ratification.
When you say they're just stating
And
facts.
the point that we make, almost embarrassing in its simplicity at the end of the day, is to say there's nothing in that language to indicate that a party, and we do ask the court to bear in mind as a potentially relevant factor that this is an unrepresented party in a different
I think that's a terribly
system.
good point, given that they're hardly unsophisticated parties. But anyway, carry on.
But we say any party which is said to have acknowledged by these letters the validity of 71 million euros of debt, one would look for particularly clear language, or one would look for tolerably clear language.
It's not a matter of acknowledging the debt, though, is it?
Of acknowledging the validity of the debt through ratifying the unauthorized acts of the BNC staff carried out in any assignment of the debt.
I'm sure it must be being dense, but I'm struggling to find the second phrase in the letter. So the first phrase, I understand your submission, because that's it. What the sentence actually said is, we refer to your letter regarding. So you say, well, that's just simply saying what the letter was about. And that I can understand. But where's it signed bilaterally, etc.? Where's that coming from?
So this is the second letter.
No.
This is in, my lord's referring to subparagraph 10.
Yes, I'm looking at the letter of the 30th of December 2019. I'm trying to find that phrase in that letter. And it may be there, I'm just not finding it.
I'll go back to the letter. That's in the second paragraph. This is supplementary bundle, page 43, tab 13.
But that's a different letter.
Yes, so she's referring at subparagraph 8, she's referring to the first letter that was sent by Mr. Fernandez. Then at subparagraph, and if we look at subparagraph 9, she records the furthest letter from CRF to BNC, so that's the second Gibson Dunn letter, and at subparagraph 10, she's then quoting from the second letter by Mr. Fernandez, and we have that at, in the supplementary bundle at tab 13.
All right, I see, yeah, thank you.
And the signed bilaterally wording is in the second paragraph.
Yeah.
Mm-hmm.
So in the judge's findings, subparagraph 8 deals with Fernandez 1, and subparagraph 10 deals with his second.
That was the point I failed to understand, thank you.
And so to round off the ratification point, the simple final point that we make is that in our submission, this wording falls short of what would be required for Mr. Fernandez to have ratified the unauthorized acts, the critical one of which the judge had found was the 13th of June email from Ms. Marty. So we say that ratification doesn't provide, based on these letters, a cure for any deficiency that the court might find under ground 1 in the
I'm
Cuban
sorry
law.
to keep on asking dense questions, or stupid questions, to put it more accurately, but do I understand that the second letter, the 27th of January, is also a translation?
Yes.
Because we have the translator's certificate for the first one, but not for the second one, but it is also a translation.
Yes, it is, my lord.
Thank you.
I think that's just a glitch of the
Fine, I just wanted
bundle
to check that
refining
out.
process.
Thank you.
They were both in Spanish.
Yeah.
So that rounds off our case on ratification. The next point that arises is the argument raised by CRF at point 2 of its respondent's notice. This argument arises if the court were to find for BNC on the Cuban law points, and so to find that BNC didn't validly consent to the 2019 request for consent to assignment. Now, in those circumstances, CRF, as well as raising the ratification argument that we've just addressed, CRF also asks you to uphold the judge's order on various bases, including in this paragraph, a submission that BNC's refusal to consent to the assignment, or, take it a step back, that the events of 2019 amounted to a refusal to consent to the assignment, that this was unreasonable, and that this unreasonable withholding of consent has certain legal consequences. Now, this argument by CRF, and of course I appreciate they haven't had the opportunity to develop it yet, so I will, I'm likely to give our response in outline and of course wait till reply to fill in any detail that needs to be done, particularly given the time. But the court will appreciate that this argument has 3 steps for CRF. They have to establish, firstly, that what happened in 2019, which the court looked at this morning, amounted to BNC withholding its consent within the meaning of the contract, and I'll look at the relevant clause in a moment. Secondly, that that withholding was unreasonable. And thirdly, that that unreasonable withholding has the consequences, as a matter of English law, that CRF says it does, which they say is to release CRF from the requirement to obtain BNC's prior consent, or to allow this court to proceed as if that requirement had been satisfied. So I'll address you on the first 2 propositions and briefly on the third. Now, we can see the relevant clause of the contracts. They are materially identical, so we can just look at one of them. If we have the core bundle, it's at tab 14. This is the IBI agreement. And if we go over the page to bundle page 227, we see heading 17, clause 17, heading assignment. And if we go down to 17C, bank, and of course the court will bear in mind that somewhat confusingly, although BNC, the bank, is the appellant here, the bank as referred to here is IBI. BNC, within the terms of this agreement, is the borrower. The bank, we see clause 17C says the bank, subparagraph 1, bank may assign all or part of its rights under this letter to any holding company or subsidiary, or any other subsidiary of a holding company without consent of the borrower. Well, that's not in play here because there's no such relationship between ICBC, the assignor, and CRF. So we're into the next part of this provision, or to any other person with the prior consent of the borrower, so the borrower being BNC here, such consent not to be unreasonably withheld. So very familiar contractual language. Now, we can see what the argument was and how the judge addressed it in one go. If we go to page 156 of the bundle, this is tab 8, the judgment starting from paragraph 358. Court will see the heading towards the top of the page, withholding of consent. And again, the judge notes this proceeds on a considerable degree of contingency. The reason, of course, being that she had in fact found that BNC had validly consented to the assignment. So she goes on at paragraph 359, subparagraph 2, to conclude that as regards BNC, so far as 2019 is concerned, there was a seeking of consent, but no withholding of consent. So she concluded at 360 that in those circumstances it was not appropriate to go on to consider the hypothetical question of whether if there had been a request and a withholding, such hypothetical withholding would have been unreasonable. And here she cites the dicta of Lord Justice Henry and Lord Justice Millett in Henry and Chart Search. So what we see is that before the judge, CRF's three-stage analysis that I just outlined fell at the first hurdle, since the judge held there hadn't in fact been any withholding of consent. Now,
so in 359 she states conclusions. Is there any reason elsewhere?
No, this is the analysis.
It's a bald statement of
It's a bold
conclusion
statement.
with no reasoning.
Precisely. Had the matter arisen, I would have found that, as regards BNC, there was a seeking of consent, but no withholding of consent. Of course, there are reasons in that, well, there is analysis in the sense that she has, in the factual section of the judgment, set out everything that's happened in 2019.
But if consent is sought and not given, why is it not withheld?
Well, that's the point that CRF raises. So they say, and we have this from paragraph 59 of their skeleton, they say that where there's a defective consent given, that necessarily amounts to a withholding. So they say that it's binary, and there was, this is paragraph 59.
It depends on the premise, doesn't it? I mean, so do you accept the premise that consent was sought?
Yes.
And you also accept that it wasn't given? That's your case. It's not just you accept that. You positively assert that it wasn't given.
Well, that's the way that CRF would put it. CRF puts it as, and the way they put it in their skeleton...
It's a key part of your defence of this whole claim, is you say there was no prior consent as required for the assignment.
Yes.
That was an affirmative defence you put forward.
Yes.
And by this stage of the argument, one has to say, assume you've succeeded on that.
Yes. And see, the way that CRF puts it is the question is a binary one. Either consent is granted or it is withheld. It makes no difference whether consent is withheld by an outright refusal or by silence, or because what appears on its face to be consent is, as a matter of Cuban law, not consent. Now, in our submission, so the question is there a space, is this question truly a binary one? So is every situation where consent is not validly
all right,
given...
But before you develop the argument, I still want to get straight the premises. So you've accepted premise 1, which is that consent was sought. When I asked you about premise 2, you didn't accept that, but I'm still struggling to understand your position. It may be my fault. So we assume by this stage that and we have to, because if we don't make this assumption, the question doesn't arise. You've prevailed on appeal ground 1, and therefore there was no prior consent, which is your case. So therefore, we have to proceed, do we not, on the basis that consent was sought but not given. And if you don't accept that, I'm struggling to understand why not.
We accept consent was sought, consent was not validly given as a matter of Cuban law, but we do not accept that that equates to consent having been withheld in the manner that we see set out in clause 17C. So the difference between CRF and BNC on this point is that CRF says every non-consent...
That frames the debate.
Precisely.
What you say is, yes, we didn't give consent, but no, that does not equate to withholding consent.
Precisely.
Right.
So the difference between the parties is that BNC says everything that happened through the summer and autumn of 2019, BNC going backwards and forwards, asking for documents, checking documents, sending emails, sending letters, that, we say as a matter of Cuban law, did not ultimately reach the point of a valid consent. We say, on the other hand, though, that the judge was entirely correct to say that doesn't amount to a withholding of consent within the meaning of the contract. So the difference between the parties here is there logical space for action to be taken by a party that is neither consent nor not consent?
Yes, does withholding mean something additional?
Precisely. Do you withhold by trying to do the thing, going through the steps of doing the thing, but there's an invalidity in it, as we say? Is that meaningfully a withholding? And the judge said no. We say that was correct.
And suppose my neighbour wants to chop down a tree on the boundary, and I don't want to agree to it, but equally I don't want to give offence to my neighbour. So every time he asks me, I avoid answering the question. Why have I not withheld consent?
Well, in that situation, and we have exactly that. It's not your lordship and a tree, but it's a similar situation in the bundle. There's a case of Gab and Farahzad, tab 15, and we entirely accept that there will come a point where the person whose consent is being requested, so Gab and Farahzad, the requestor, wrote and wrote and wrote. It was several flats in a building, wrote and wrote and wrote, just got no response, and it had been established that the requests were being received. It seems that it was just a rather truculent person who was receiving them. He never said no, and he thereby, I think, thought he could insulate himself from ever having breached the terms of the contract. But the court found that there comes a point when if you simply ignore repeated requests for consent, then as a matter of common sense, you have to be taken to have withheld your consent. So we entirely accept that that type of situation is going to, at some point, and it's obviously a matter of judgment, how many requests have to be ignored and how long it has to go on for. The context will be important, but there comes a point when complete inaction will amount to a withholding. And there doesn't have to be, and one can see the sense of this, it doesn't have to be a positive letter.
If given you accept that silence can amount to withholding, what's the test?
We don't seek to formulate a test that would deal with all situations. It's going to be fact-specific, but we say in a situation that we're dealing with here, where a party positively engages, positively takes action towards the objective that's requested, and at the end of the day there is a legal invalidity in that, we say that meaningfully that cannot be characterised as a withholding.
But can you say that BNC, the party, did take steps? Because nothing that was done was authorised by BNC.
Well, no, we say that it was not authorised as a matter of Cuban law, but it's still difficult to characterise that as a withholding of consent, because that implies an intention not to consent. We've seen the correspondence, we see the steps being taken, we see them, Ms. Marty asking for documents being sent backwards and forwards. That's all real engagement. Flawed, we say, ultimately as a matter of Cuban law for the reasons you've heard this morning, but that's real and genuine engagement, which...
So you're saying that for withholding there needs to be a lack of engagement, or alternatively a false facade of engagement with no intention of doing so.
Precisely. So if there had been, and one can posit different circumstances, either a lengthy silence in the face of repeated requests which have been received, so that's Gab and Farahzad, or perhaps a situation where, as Manedi suggests, a party engages as a false front to ultimately want to be able to say that the engagement was legally flawed in some way, then again, that may be withholding. CRF, of course, says that's this case, and we say that the legal deficiencies in the situation stem from matters which were open, or the handbook, the rules, the signature requirements, which were not concealed. So we say, and there's no suggestion of that those matters were not available to CRF. So CRF would say that the second type of case that the ladyship posited is this case, and we would say it isn't.
You say no, and there was no garden path that they were being led up.
No, not at all. And the case law, this court has certainly, and we cite the case in our supplementary skeleton, paragraph 8.3, we cite the case of Barbados Trust and Bank of Zambia, where we can see the court, this is just paragraph 60, we probably need not, it's quite an involved set of facts in that case, but we'd ask the court to note that paragraph 60, very different circumstances in terms of the background to the request for consent, but we can see this court being entirely comfortable with the idea that there is terrain between refusal or defective attempts at consent and withholding. And we highlight paragraph 60, where the court notes a similar problem can arise where the debtor replies within the 15 days. This was the 15 days required in the contract in that case, but without either giving or withholding consent. So the court, we accept different fact pattern, but in that case, certainly sees space between giving and withholding. So sees space for what we say is the possibility that a party doesn't lead anybody down the garden path and doesn't just sit silently, engages, but ultimately not to a conclusion that's legally valid. And we say that's not meaningfully a withholding, and that the judge was correct in the conclusion that she reached on that. Now the judge, because of the conclusion that she reached on that point, didn't go on to consider whether, if there had been a withholding at that point, it was unreasonable. The reason she didn't deal with that, we see this at paragraph 360 of the judgment, she cites Hendry and Chart Search, and she says, to the effect that if there was no withholding, it wouldn't be appropriate to go on to consider the hypothetical question of whether, if there had been a withholding, it would have been unreasonable. Now, this question, of course, would arise if, contrary to the submissions I've just made, the court were to find that there had been a withholding in the sense that the contract contemplates, by reason of BNC's actions in 2019 and the ultimate invalidity of the assignment process. So
sorry, I'm afraid you've disappeared.
I'm sorry. I'm not sure I can compete with that, Kelly Foster, but I was saying that the question of reasonableness would arise if the court was against me on the submissions I just made and found that what happened, that BNC's conduct through the summer and autumn of 2019 did amount to a withholding of consent. Then the court would have to go on and look at whether that consent, that withholding had been reasonable or not. I can take that, conscious of the time, I have one more ground to get through, but the question of reasonableness comes up slightly elliptically later in the judgment. CRF relies on the judge's observation at paragraph 377.
377.
Subparagraph 1. So she looks at 2019. She then looks at 2020. Now that's not a matter. The 2020 withholding definitely was a withholding of consent because CRF asked BNC again in 2020, and BNC said no in turn. So there certainly was a withholding of consent in 2020. So the judge went on to consider whether that was reasonable. And she decided that it was reasonable. Her reasoning on that is paragraph 374 for the court's note, but this is not before the court on this appeal because this point it was raised in the respondent's notice but withdrawn a couple of weeks ago. So the court doesn't need to consider the 2020 withholding, but having skipped over that, we go to 377. This is at the top of page 159. would offer to close the windows, but it's also quite warm. So it's a balancing act between warmth and
I don't think it'll
noise.
help very much anyhow, so just shout.
I will. So, CRF, in relation to the reasonableness or otherwise of what CRF says was the withholding in 2019, she says it's 377. So just and you,
I think we're going to, I'm not sure whether closing the windows is going to help.
It might help just for
Yeah.
5 minutes.
Please may we ask one of the judicial assistants there to use some muscle for us, or more than one, both here and there. Thank you very much. A marginal improvement. Right, so we're at paragraph 377.
3771. So
Thank you.
she says, after 2019, there was no unreasonable withholding of consent. That's the very short finding that we looked at over the page, because there was no withholding. Then CRF rely on the next sentence. Had there been a withholding on the basis of CRF's nature or approach, it would not have been reasonable. Now, this is said in a context where the judge, and we saw she cites the authority of Hendry and Chart Search at paragraph 360 to say it wouldn't be appropriate where you find there wasn't a withholding. It's not appropriate to go on and decide whether hypothetically, if there had been a withholding, would have been reasonable. So she sets herself that limit. She then goes on
does
and
it, you say?
and she then makes the remark that she makes at 3771. Now, CRF characterises this in its skeleton at paragraph 62 as a finding by the judge that, in their words, there was no valid basis on which to withhold consent in 2019. We say that's clearly not a finding because she set herself the limit that she sets at 360. There's no reasoning on this point. It would have been contrary to the authority that she cites, Hendry and Chart Search, to go on to make that finding. And we also say, though, if that is how 3771 is to be interpreted, then we do challenge that finding. Since the point arises as a result of the respondent's notice, it's not in the grounds of appeal, but we would, if necessary, if the court thought necessary, we would amend the grounds of appeal accordingly. But we simply would invite the court to treat 3771 not as a finding to this effect, and we would make some brief submissions, obviously subject to responding to anything that CRF says on the reasonable.
Very sorry to go back, but briefly, what's the relevance of 360? Because both the two citations from Hendry are about where consent has not been requested, whereas there's no dispute that consent was requested in the present case.
Yes. Well, I accept it's not
And
a direct...
equally, there's no dispute that consent was not given. There's an argument as to whether the not giving of a consent equates to withholding, and you say it doesn't. But if you're wrong on that, why does it not then follow that one has to consider reasonable?
So, firstly, in terms of what the judge is saying at 360, our reading is that, of course, I take the point that it's not precisely on all fours with the situation that she had found existed here, but that the broader point she's making is that she's not going to engage in a hypothetical, since she's decided that there's no withholding in the sense of the contract.
The problem with 360 is, as you can see, she's aligning or grouping together two different questions. One is the position as regards Cuba, where there was no request, and therefore no withholding. And BNC, where there was a request, but she says no withholding. But the question of the hypothetical inquiry is different, as Hendry shows, because it's one thing to say, well, it's pointless to go into this if there's no request for consent. It's a different ballgame altogether if there has been a request for consent and it's not been given, even if you find that it's not been withheld.
Yes, and I accept the dicta that she quotes there are not on all fours with what she had determined to be the case in relation to BNC, which was that there had been no withholding. But the general point she took from those dicta was that the hypothetical exercise, and it would have been a hypothetical exercise for her to go on and say, I've found there was no withholding in 2019, but I'm still going to analyse.
The point of raising this is, does that not, if you understand the distinction between the two situations she's dealing with, does that not make what she does in 377 more understandable? Because certainly as regards BNC in 377, where there's no dispute, consent has been requested, if she's wrong on withholding, it's therefore more understandable for her to then deal with the question of reasonableness.
Yes, potentially. I think I understand the question that's being put to me. We accept that the passages that she cites at 360 don't in terms bar her from making a finding. CRF relies on the second sentence of 3771, and we would briefly address you on why, if that is a finding, that it would have been reasonable to withhold consent in 2019. We address you, the point that arises for me to address the court on is then why that wouldn't be a sustainable finding. And that starts with the test for reasonableness in this context, and she sets out the case law at 361 to 364. We have the decision of Mr. Justice Eder in Falconera Shipping, which she cites at 361. I invite the court to read the quotation there. And the final sentence in our submission sets quite a high test. Mr. Justice Eder says, "Thus I accept the owner's submission that they were only in breach if no reasonable ship owner could have regarded their concerns as sufficient reason to decline approval." So the test is framed there as a high bar for CRF, we say. Question is whether they can establish that no reasonable, and it was ship owner in that case, could have refused. And then we see at 363, the judge cites a further passage from the same decision, the Falconera, indicating that the reasonableness of the withholding must be judged at the time that the withholding took place and on the basis of the information reasonably available to the person who took the decision. And one further point, perhaps important in this context, and the court will recall what Mr. Fernandez said in his letters about the economic position of the country when he was responding to the letters of claim. A further point that BNC raised at trial but not mentioned in the judgment is that, and this is the case of sequent nominees, we have this in our skeleton and we have this at tab 13 of the bundle, but it's 9.2 of our supplementary appeal skeleton, is that the economic consequences of giving or refusing consent are relevant to a determination of reasonableness. So, applying this to the situation where the court were persuaded by CRF's argument that there was a withholding in the sense that the contract contemplates of consent in 2019, we'll of course hear what CRF has to say about this, but the points that we would draw the court's attention to are firstly that CRF had been specifically set up to buy Cuban debt. This is recorded in the judgment at paragraph 23. Secondly, CRF sought to acquire the rights under the agreements for the express purpose of immediate enforcement. And we have this from the witness statements of CRF's two witnesses of facts, and again, to save some note-taking, all the relevant references are at paragraph 9.3 of our skeleton. Thirdly, this is consistent with press articles from 2018, so going to what material was reasonably available to the putative withholders of consent In 2019, we have, in the supplementary bundle at tab 7, we have a CNBC article from the 9th of February 2018, noting that an ad hoc London Club committee of creditors, of which CRF was one, had retained lawyers and, quote, could resort to the courts. Measures they could pursue include seizing assets and interrupting Cuba's international payments and trade. So fairly aggressive measures being reported there as being potentially resorted to by this group of creditors. And in the same vein, at the second supplementary bundle, tab 8, a Bloomberg News report from the 3rd of May 2018 stating that CRF had hired Gibson Dunn, which had won a substantial debt settlement with Argentina. So, in other words, experts in the field of enforcement of sovereign debt. Now, we've just seen that, and we cited the case of sequent nominees for the proposition that the economic consequences of granting the request can be a reason for refusal. In this case, we say that a reasonable sovereign debtor might have taken into account the dire economic backdrop against which it was being asked to consent to the assignment of the debts, together with the press about CRF being prepared to enforce the sort of aggressive measures I just cited from the press article. So taking the test as Mr. Justice Eder articulated it in the Falcon era and as the judge applied it, the question for this court is whether no reasonable sovereign debtor in an impoverished state could have withheld consent to the assignment of these debts to a fund specifically set up, as the judge found, to enforce the distressed debt of that state, and which intended to move to immediate enforcement of these very debts. Now, as I said, although the judge made no finding formally on the reasonableness of the refusal, because she found that there had been no withholding, to the extent that the judgment could be said to be inconsistent with the submissions I've just made about the facts which would have justified a refusal, we do submit that the court should depart from her reasoning.
What your submissions amount to is saying it might be reasonable to refuse to consent to the assignment because you don't want to pay the debt.
Lord.
All the factors you mentioned relate to the fact that CRF might actually seek payment.
Yes.
But
we say
can a debtor, the reasonableness of consent must be viewed from the point of view of the existing creditor is the one who is seeking consent to assignment. And is it unreasonable in the context of where the creditor wants to realise something from this debt and wants to assign it to somebody who will actually take steps to enforce it? And can you be seen to say, well, it's reasonable for us to refuse them the right to realise that those monies in relation to this debt because the person they're going to assign it to might actually take steps to enforce against us?
Well, no, that is
quite tendentious to me.
That is a submission that we make, that we're not talking about a generalised proposition that would apply to all debts. It'll obviously depend on the specific context of the particular case. So here we have a sovereign debt held by an impoverished state, decades old. Over decades, it sat with banks and other creditors, changed hands, nobody seeking to enforce it. Now, would it be, could this court conclude that no reasonable sovereign state and sovereign debt instrument could be refused assignment or refused consent to assignment because of the potential economic consequences to the state concerned? And in our submission, in that context, the state and the bank were not acting unreasonably, and it would be possible to say it was no reasonable sovereign debtor could take into account the fact that the debts were to be transferred or were sought to be assigned from one creditor, which, like all those in the preceding decades, were simply sitting on the debts, to one which was very public about its intentions to move to aggressive and disruptive enforcement action against a backdrop that Mr. Fernandez outlined in his response to the letter. So in our submission, that is reasonable. Or
is it appropriate to take into account the fact that, in fact, BNC plainly did not consider that it was unreasonable to consent? Well, your point about consent isn't that you didn't seek to withhold it on the grounds that it was that it would not be unreasonable. You say it's a pure technical problem with authority. Is why you didn't consent.
Well, we're doing two things. On the analysis I've just outlined, we have to look at what. And again, we're in a hypothetical situation. If those concerned had decided that the answer was going to be no because of the nature of CRF, we say it's impossible to say that no reasonable party could have acted in that way. In reality, yes, those concerned were not aware of, as a matter of their subjective appreciation, were not aware of CRF's plans, and indeed it was ICBC dealing with the assignment, and CRF held much of this debt, including the two instruments that are the subject of this case, through sub-participation agreements which were not revealed to BNC. So it's actually quite a can of worms that was explored at trial in contexts which then don't arise as matters for this appeal. Quite a can of worms, if I can use a non-legal term, what was known and what wasn't, and how open CRF were. And as I say, this is all sub-participation agreements with ICBC. So if CRF or ICBC had said, we intend, and they did not, we intend to move to immediate enforcement of these debts, then one might infer that the answer in 2019
isn't that another reason
would have been different.
why the nature of the assignee, in a sense, can't come into it? Because, as you rightly say, it can be done by way of sub-participation anyway. So the technical transfer of title to the debt doesn't necessarily dictate whether or not CRF can pursue the debts against the bank.
The specific question before the court here, though, is a fairly narrow one. It need not reach sweeping conclusions about the relevance of the economic consequences of every debt, any debt, as a matter of overall principle that may be sought to be assigned. I think the question that my lord was raising specifically, the last question that was raised was, what is the court to make of the fact that that BNC, through the summer of 2019, willingly pursued the assignment? Doesn't that suggest that they were, in fact, comfortable with the nature of CRF as a new creditor? And the submission I was making was that there's a lot more to it than that, and they weren't aware of the nature of the alleged creditor. Now, the prior question that arose, of course, was would a and again, we are in a very hypothetical, we say there wasn't a withholding anyway. Nobody, and I think it's common ground, nobody in BNC in the summer of 2019 had a state of mind that was, no, we don't want to do this. But by the step-by-step approach which CRF takes, it may be, if the court decides that consent was withheld by the series of events that we've seen, then the court may have to look at the question of reasonableness. Again, we don't have a real person who gave evidence or could give evidence to say, I said no, and I'll tell you why. There wasn't such a person because that wasn't the nature of the events we're dealing with. If there had been such a person, then I've outlined the factors that we say they would have been in the very specific context of a substantial transfer of sovereign debt in the context of this particular state, not be as circumstances where the court could say no reasonable debtor could have said no to having the debts move from a bank that was just going to sit on them to somebody who was going to, as we've seen, write asking for 71.8 million euros within 14 days. I am
Ms. McDonough.
reminded
I'm very
that we
concerned
need
now
to,
about the time, though.
I am reminded that we need to save some time for reply. We have a further point, which is on notice of assignment, but I think I don't want to develop that at the expense of allowing us to respond to the other matters there. So the court has the point that we make on the validity of the notice of assignment. This is at paragraph 34 of our skeleton, and it's also, because CRF makes some points in response, it's also addressed as the final section of our supplementary skeleton. So we'll respond to anything that they say on that. I don't not develop it now because of a lack of enthusiasm in that point. It includes a very nice phrase by Lord Hoffman about pink paper and blue paper, but I'm concerned to make sure that we save some time for reply. So subject to any further questions from the court, those are our submissions.
Thank you very much indeed. Before we go on, I'd be grateful if the judicial assistants would come to our aid and open the windows again before we all expire. Thank you very much. Mr. Cushy. Thank you.
May it please you, my lady, my lords. I propose to address first the main issue which arises for determination on this appeal, and that is the challenge, by way of the first ground of appeal, to the judge's conclusion that Miss Marty validly gave prior consent on behalf of the appellant, BNC, to the assignment by a creditor, that is ICBC, to the respondent, my client CRF, of ICBC's rights and obligations under 2 English law debt agreements. We say that the judge was entitled to come to the conclusion she did, both because there was, as the judge found, no requirement for the use of any signatures when giving consent in principle, and also because, as the judge found, the act of giving consent to an assignment by ICBC to CRF was not a banking operation within the meaning of the BNC signature rules. But even if BNC had been able to show some defect, technical defect in the giving of its prior consent, which affected the validity of that consent, we say that there would in any event have been 2 separate answers to BNC's reliance on any such invalidity. First, we say that on a proper construction of the assignment provisions in the agreements, the failure validly to give prior consent when requested would have amounted to an unreasonable withholding of consent. That is the issue raised by the second paragraph of the respondent's notice. Any withholding of consent in 2019 was unreasonable. But secondly, we say that BNC ratified the acts of BNC's officials, as the judge found, and that is the subject of BNC's second ground of appeal. I will be dealing with the first of those 2 further answers, the unreasonable withholding of consent in 2019, and also the issue raised by the third ground of appeal, the challenge to the judge's findings with respect to the giving of notice of the assignments. And Mr. Pearson will address the second of the 2 further answers that we have, ratification. And my lady, my lords, we're entirely in the court's hands as to the order in which those issues are covered, but we were proposing to respond to the grounds of appeal first. It seemed to us that that was important, to deal with the grounds of appeal, before addressing the yet further reason we say the judge's decision should be upheld. And on that basis, and with the court's permission, we propose that after I address ground 1 of the appeal, I should address ground 3, notice, and Mr. Pearson then ground 2, ratification, and that I should then use my remaining time that is available to us to address the further ground we have raised by the second paragraph of the respondent's notice. That's the unreasonable withholding of consent, and I can cut my cloth accordingly on that last ground, which seems to me to be where I should be cutting my cloth, rather than in relation to the grounds of respond to the grounds of appeal themselves. So, my lady, my lords, turning then to the first issue, and the judge's conclusion that by her email of the 13th of June 2019, Miss Marty validly gave prior consent on behalf of BNC to the assignment of the rights
and the transfer of obligations under 2 debt agreements from ICBC to CRF. And my lady and my lords will forgive me if I take this with some care, and if I identify first all of the relevant findings made by the judge before turning specifically to address BNC's ground of appeal. And there is some ground to cover, so I hope again the court will forgive me if I press on by identifying from the judgment the findings that the judge in fact made. But just before then, I start with the debt agreements themselves, which were an issue in this matter. That's the Credit Lyonnaise Agreement and the IBI Agreement. Both of those agreements were governed by English law, and both of those agreements permitted the bank, that is ICBC for these purposes, an English law right to assign its rights and to transfer its obligations under the agreements to another person with BNC's prior consent, which consent was not to be unreasonably withheld. The relevant provision in both agreements is Article 17C, which the judge set out at paragraph 10 of her judgment, that's page 74, but I think we looked at in the IBI agreement itself, which was in the core bundle as well, tab 14, page 227. Just pausing to look at the provision, the key provision, Article 17C. As the court will see from page 227 of the core bundle, Article 17 is headed as assignment, and then Article 17C provides by paragraph 1 that the bank, and that is ICBC, may assign all or part of its rights under this letter to any other person, that is, any person other than the holding company or subsidiary of ICBC, with the prior consent of the borrower, that's BNC. Such consent not to be unreasonably withheld. So paragraph 1 deals with the assigning of rights. With consent, such consent not to be unreasonably withheld. And by subparagraph 2, Article 17C provides similarly in relation to the transfer of obligations. Now, the court will note that there are 3 elements to these provisions. First, there are the rights to assign and transfer. ICBC had the right to assign its rights and the right to transfer its obligations under the debt agreements to CRF. Those are the rights that are conferred by Article 17C. But secondly, there are the conditions on the exercise of those rights. ICBC had to obtain BNC's prior consent to the assignment of rights and the transfer of obligations. And then thirdly, there are the provisos to those conditions. BNC was not unreasonably to withhold its prior consent to an assignment of rights or a transfer of obligations. So rights, conditions, and then provisos to those conditions. And we will say that unless BNC had reasonable grounds to withhold its consent, these contractual provisions envisage that BNC would give its consent to an assignment or transfer. And if such consent were not given when it ought to have been, then as I shall come back to, we say that the consent will have been unreasonably withheld, such that the provisos to the conditions will not have been satisfied, and with the result that those conditions will fall away and ICBC's rights to assign and transfer will have become unconditional. That, as I say, is a point I'll come back to, but it is how we say that this contractual machinery is intended to operate on a proper construction of the assignment provisions in the agreement. But at this stage, rather than taking up time on that point, at this stage, my lady, my lords, I pause to observe that the judge had no difficulty in concluding that prior consent was given to the assignment by ICBC of its rights and the transfer of its obligations under the agreements to CRF. And having set out the factual chronology at paragraphs 91 to 157 of her judgment, that's on pages 93 to 106 for the note, the judge addressed the issue of prior consent at paragraph 222, which is in the core bundle, tab 8 for the judgment, and then page 123. And in paragraph 222, the judge identified the relevant question as being whether the acts relied upon by CRF constitute prior consent, it being common ground that under the agreements, ICBC only had an English law right to assign with prior consent, such consent not to be unreasonably withheld. And having identified that question in paragraph 222, the judge answered it in the very next paragraph, paragraph 223, where she stated, overall, I have no difficulty in concluding that as a matter of fact, prior consent was given. And she went on to identify the relevant documents, including at paragraph 224, the request for consent made by a Mr. Dagba at ICBC. And then over the page, at paragraph 225, on page 124 of the bundle, the judge identified the email that was sent in response to that request by Ms. Marty, the manager of the Foreign Debt Department at BNC, on the 13th of June 2019. And in that email, Ms. Marty stated, we accept in principle the assignment from ICBC to CRF, and then she asked to be provided with the necessary documents, including a joint seller notice of assignment and buyer agreement to be bound, signed by ICBC and CRF. Then at paragraph 227, on page 125 of the bundle, the judge noted that there was nothing unusual about such emails, the process being echoed in the BNC handbook, and she set out the most important extract from the BNC handbook in that paragraph. But the judge had already addressed the BNC handbook more fully at paragraphs 89 and 90 of her judgment, back on page 89 and 90. And if we may just look at those paragraphs just momentarily. At page 89 of the bundle, paragraph 89 of the judgment, the judge noted that the handbook is a document issued pursuant to the relevant provision of Cuban law and is intended to set out the relevant processes to be followed within the BNC. Whilst the handbook covered various matters, Chapter 6 described the operations carried out by the Foreign Debt Department of BNC, of which Ms. Marty was the manager. And amongst its terms, we can see from paragraph 90, on page 90, starting there, there's a quotation. But amongst the terms in the BNC handbook, if we turn over the page to page 91, there's a heading towards the top of the page, number 2, process for the materialization of assignments. And under that heading, immediately under that heading, the handbook provides that generally a communication is received first via telex, SWIFT, fax, email, or document from a certain bank, company, or financial institution, explaining the intention to assign an amount of our debt to another entity. And then the handbook goes on to explain that various checks are carried out, including verifying that the bank requesting an assignment is registered as the holder of the relevant debt in BNC's Register of Debt Assignments. Then at the top of page 93 of the bundle, in this quotation, there is the provision which the judge quoted later in her judgment. If there is a positive result in all the aforementioned checks, a telex, email, SWIFT, or fax is sent to the foreign party, informing him that it is accepted in principle, your request, and that you must send us, that is the Foreign Debt Department of BNC, a set of original and 2 copies of the official documents of the assignment, duly signed by the buyer and the seller. So going back to paragraph 228 of the judgment on page 125. The judge noted in paragraph 228 that Mr. Lozano, who was the director of operations, who had responsibility for the Foreign Debt Department at the material time, Mr. Lozano confirmed that the sending of such emails giving consent in principle was standard practice or pro forma. And at paragraph 229, the judge recorded that there was disagreement between the parties as to whether Ms. Marty's email of the 13th of June 2019 giving consent in principle amounted to prior consent. There she identifies the issue, whether it amounted to prior consent for the purposes of Article 17. And she concluded that it did. The judge said at paragraph 232 on page 126, at the end of the day, the 13th of June 2019 communication looks like a prior consent. It fulfills the logical requirements of being an answer to a request which predates the assignment, and it conforms to the terms of the procedures set down by BNC. That's in its handbook. It is, therefore, prior consent. And although that prior consent came with a subjectivity, the judge also had no difficulty in concluding at paragraph 234 on page 126 that the subjectivity was a condition subsequent, but in any event, at paragraphs 236 to 240, that the conditions imposed on the consent were fulfilled. So the first material finding is that prior consent was given. But then...
That's a matter of fact.
That is, but this is now, I wanted to set this up because it's important in this context. The judge then addressed an argument raised by BNC at paragraph 246 on page 127. That is an important paragraph. The judge addressed a further argument which had been deployed by BNC with respect to the need for two signatures in connection with the 13th of June 2019 emails, and she makes some findings. Important findings, to which I shall refer in a moment. But it is important, my lady, my lords, understand where this fits in and what it says. It is, I flag it for the moment. I'll come back to it shortly. But just before then, again, what I want to cover is the question of authority of Miss Marty. I should like to look at the judge's consideration of the question whether Ms. Marty, as the manager of the Foreign Debt Department at BNC, was authorised to give prior consent on behalf of BNC to an assignment of rights by a creditor of BNC, that's ICBC, to a third party, that's CRF. The Foreign Debt Department being the very department within BNC which was responsible for registering, controlling, servicing and dealing with historic Cuban sovereign debt, including the giving of prior consent. And in this connection, at paragraph 303 of her judgment on page 143, the judge noted in paragraph 303 that CRF had contended at trial that the president of BNC may delegate his power by appointing officials to positions with BNC and delegating his authority to those officials to perform acts inherent in their functions. And that CRF had further contended that Ms. Marty had been so appointed to her position with BNC and that the president of BNC had delegated to her his authority to consent to an assignment of historic Cuban debt from a creditor to a third party. That was recording CRF's contentions. And for this purpose, the judge noted at paragraph 307 on page 114 of the judgment that CRF looked to the Cuban Decree Law 181 of 1998 on Banco Nacional De Cuba, the legislation which regulated BNC, which provided by Article 15 that the president of BNC, whilst exercising his functions, may grant the powers he deems necessary and delegate his faculties to other directors and functionaries of BNC. And a similar provision was contained in Article 17F at the top of page 144. And for what it's worth, CRF also looked at the statutes of BNC. So as well as the decree law that the judge referred there, CRF also looked to the statutes of BNC, which contained similar provisions. I don't need to take up time now, but they do in Article 18 of the BNC statutes, as the judge recorded in paragraph 13 of her judgment. Now, the judge addressed this method of delegation, that is delegation to officials, at paragraph 311 to 320 of her judgment, starting on page 144. And at paragraph 311, the judge noted that although BNC's expert, that's Professor Mendoza, seemed to dispute in his written report the possibility of a delegation in this way, orally he realistically accepted that the president of BNC may delegate his powers by appointing officials to positions within BNC and delegating his authority to those officials to perform acts inherent in their functions. And at paragraph 312, the judge said that that was plainly a sensible concession in the face of the wordings of Article 15 and 17F of Decree Law 181 of 1998, and also for a second reason, the significance of which I shall return to in a moment. And then at paragraph 313, the judge recorded the following. She said, "It follows, and Professor Mendoza accepted, that the president of BNC may appoint managers and officials to specific positions within the bank, that the president may delegate his powers to those managers and officials to perform acts inherent in their functions, and also three, that where the president of BNC has delegated his powers to a manager or official in this way, the manager or official is authorized to represent the bank in its external relations within the limits of the authority and power that has been delegated to them." And that latter point, accepted by Professor Mendoza in cross-examination, followed from the terms of Article 54 of the BNC statutes, which I think we saw in the supplementary bundle. If we may just go there for a moment. In the supplementary bundle, in tab 1 at page 12. Article 54 of the BN statutes provides by its first paragraph on page 12 of the supplementary bundle, in its external relations, the bank shall always be represented by its president or by the manager or officer to whom he has delegated that responsibility. In addition, this is the second paragraph of Article 54. In addition, external relations can exist at various levels of management by the respective managers or authorized officials. In such cases, they only commit their respective positions or the organizational units dependent on these. So just pausing there. In the first paragraph, let's talk about binding the bank. And so far, the second paragraph says, in addition, various levels of management can commit not the bank, but their respective positions or their organizational units. And then it continues, except in the case of managers and officials given the authority by the bank to sign documents in its name. So what you have under Article 54 is the bank being represented by the president or the manager officers to whom he has delegated his responsibility. And the bank may also be represented in its external relations by managers and officials given the authority by the bank to sign documents in its name. Now, we've seen the BNC signature rules for banking operations. That's in tab 4 of the supplementary bundle, and I'll come back to that. Just at this stage, just want to highlight for the court that there was, for these purposes, a signature book at BNC containing the wet signatures of those who had signing authority to bind the bank. And that is in the supplementary bundle, a second supplementary bundle, do forgive me, at tab 6.
Do you want to turn that up?
Yeah, yes, please. I won't dwell long on it, but just to make the point that together with the BNC signature rules, there was a BNC signature book. And the signature book in the second supplementary bundle, tab 6, page 18, is the front cover. Authorised signatures.
And there you have them.
And there you have the wet signatures, including on page 22, on the middle box on the left-hand side, Miss Marty. On the right-hand side of page 22 is the president of the bank. That's his witness signature. And on page 25, on the right-hand side, in the middle, is Mr. Lozano. So to go along with the BNC signature rules, there is a BNC signature book with wet signatures of those who are authorised to bind the bank in accordance with that signing authority. I'll come back to that particular part of the story in a moment. The point for now is that the signing authority conferred by the BNC signature rules is additional. So, for example, whilst Mr. Lozano had authority to represent the bank in its external relations within the limits of his delegated authority, he additionally had signing authority to represent the bank in matters that were outside of his delegated authority. And that's how Article 54 works. Now, as far as the conferring of authority by way of delegation, it follows from the judge's findings back at paragraph 313, the findings in subparagraphs 1, 2, and 3 of paragraph 313, that if Miss Marty had been appointed to a specific position within BNC, and if the president of BNC had delegated to Miss Marty his power to give prior consent to an assignment as acts inherent in her function, then Miss Marty would have been authorised to represent BNC in its external relations with respect to the provision of prior consent to such an assignment. Now, as regards those two requirements, the judge found at paragraph 314 that Miss Marty had been appointed by the president of BNC to the position of manager of the Foreign Debt Department. And at paragraphs 15 to 19, the judge further found, this is now page 145 to 146 of the bundle, paragraphs 315 to 319, the judge further found that it was tolerably clear, that's in paragraph 319, that Miss Marty had been authorised to exercise the powers and functions of the Foreign Debt Department, that she was personally responsible for the completion of the tasks and exercising the powers and functions of the Foreign Debt Department, and that she was responsible for representing the Foreign Debt Department and for issuing binding instructions and other provisions within her sphere of competence, including, we say, the giving of prior consent to the assignment of rights by a creditor of BNC to a third party. Thus, the judge concluded at paragraph 320, page 146, that subject to any requirements of how Miss Marty was to go about performing her actions pursuant to her delegated authority, Miss Marty had authority to act for BNC in relation to consenting to the assignments by ICBC to CRF. Now, the judge expressed the subjectivity, subject to, in the way that she did for the reason she had already given at paragraph 311 and paragraph 312 on page 144. although in his written report, Professor Mendoza had seemed to dispute the possibility of a delegation other than under BNC's signature rules. In his oral evidence, Professor Mendoza accepted that the President of BNC could delegate authority to managers and officials appointed to positions within BNC under Decree Law 181. And as we've seen, one of the reasons the judge gave for regarding that as plainly being a sensible concession was the wording of the decree law itself. But the other reason, to which I said I would return, was the fact that the title of the BNC signature rules does not seem to indicate that it is prescribing the scope of the power otherwise conferred on BNC's officials, but that it is merely setting out rules to operate on authorizations and indeed signatures. So the question raised by the BNC signature rules, therefore, was not whether it went to Ms. Marty's authority to give prior consent on behalf of BNC to an assignment by creditor of BNC to a third party. She was so authorized. The question, as identified by the judge, was instead whether the BNC signature rules contained any requirements as to how Ms. Marty went about performing the actions pursuant to her delegated authority. That was the question. And as to that question of whether there were any requirements as to how Ms. Marty was to go about giving prior consent to an assignment, BNC's case was that the prior consent had to be given in a particular form with two signatures. That is what was BNC's case, and that case was considered and rejected by the judge at paragraph 246 of the judgment, back on page 128. That's going back to the important paragraph to which I said I would return, and I am now returning to it. Paragraph 246 on page 128 of the bundle bears reading in full. I'll read it first and then I shall break it down. But the judge records that an argument was also deployed by BNC by reference to the supposed need for two signatures. However, this is an argument which conflates two different issues. If consent comes at the 13th of June, which the judge found it did, the evidence as to two signatures, the requirements for it, and to the extent relevant CRF's knowledge of it, pertains to a later stage. That is reflected in the process prescribed by the BNC handbook. There is no document or evidence which suggests that two signatures were ever required for this preliminary consent. The witness evidence relied upon by BNC as to the number of signatures, Mr. Lozano's mistake, pertains to the 25th of November document. As I say, there's a lot in that paragraph. But breaking it down, the judge observed first that the evidence adduced by BNC as to the supposed need for two signatures was directed not to the prior consent given by Ms. Marty by email on the 13th of June 2019, but to a subsequent stage. It was directed to steps that had been taken by Mr. Lozano on the 25th of November 2019, after the prior consent had been provided by Ms. Marty and after the assignment had been signed and sent to BNC. The evidence, in other words, related to steps taken by Mr. Lozano, which were analytically irrelevant. The judge next observed that the evidence indicating that there was a need for two signatures at a later stage, rather than at the in-principle stage, was reflected in the process as prescribed by the BNC handbook. And as to this, the BNC handbook makes no reference to any need for any signatures in the context of the giving of consent in principle. As the judge noted at paragraph 227, we looked at this, but on page 125, paragraph 227, the BNC handbook instead provides only that a telex email, SWIFT, or fax is sent to the foreign party, informing it that its request to assign had been accepted in principle. That is to be contrasted with the steps to be taken by BNC subsequently, as reflected in a later passage quoted from the BNC handbook. And I'm afraid we'll have to go back to page 93 of the judgment to see this. This is page 93 of the bundle. We looked at this. This is part of the quotation where the judge was setting out the relevant terms of the BNC handbook, starting at paragraphs 89 and 90, pages 89 and 90. And by page 93, the judge at the top of the page quoted the paragraph, the words I've just read out, which he noted at paragraph 227. But then she goes on, after what are called the official documents of the assignment had been duly signed by buyer and the seller.
I'm sorry, where were you reading from then?
So at the end of the very top paragraph on page 93,
Yes.
is the wording about sending the accepting in principle.
Yes.
And asking for the documents of assignment duly signed by the seller and buyer. That's the assignment itself. There's a request for that. And then the words are when that document is received. So when the assignment itself has been signed, after consent in principle has been given, it is checked. The document is also sent to the legal department and they review it. And if appropriate, if it is appropriate to proceed with the assignment, according to the agreements, clauses and other details, then the legal department will say so. And then is the next paragraph. If the legal letter and all necessary documents have been provided and approved, then 4 lines down it says, then the assignment is ready to be materialized. Its materialization consists in sending both the assignor and the assignee a copy of the initial document, that's the assignment itself, duly signed by the Cuban side, containing 2 authorized signatures of BNC and a letter giving our consent for the purchase sale, leaving within the file that will work in our archives a copy of this, that's the letter, together with the original documentation, that's the assignment, and the file will be given an assignment number. So to put the point succinctly, consistently with the evidence of BNC's witnesses, the BNC handbook, which set out the process to be followed, recognized the need for signatures at the later materialization stage, but not, importantly, at the consent in principle stage.
But in that case, that must be the effective consent then, wasn't it?
The effective consent is the email in principle.
It doesn't seem to be right. Does it?
The email in principle, the prior consent has got to be given before the assignment is signed.
Your client is going to need to see, normally what you'd expect to see as a financial institution taking an assignment where consent is required, you're going to expect to see a resolution, or certainly something which demonstrates that the consent is binding on the debtor.
Well,
otherwise, you're exposed to precisely this scenario.
Well, we're exposed to the risk of an argument, but the way the clause operates is prior consent, and that necessarily means consent before the assignment is entered into. And the prior consent, as the judge found, therefore, is the email of June 2019, 13th of June 2019, which then asks for the assignment.
It's utterly bizarre then to have a situation where you don't need to have any formality in relation to the actual consent at all. What you're saying, it doesn't need any signature at all, so long as it is by somebody who's actually got consent, authority. Whereas you have effectively a fully formally authorised consent, which is too late.
You get a confirmed letter. you get a formal letter confirming consent that any sensible party would want from the Cuban side, as it's put in the BNC handbook.
It's too late.
But that's too late for the requirements in Article 17C. The requirements in Article 17C are to obtain prior consent, and that comes at an earlier
Say
stage.
it's just like landlord and tenant. If you're in a lease, you've got a requirement for prior consent to an assignment of the lease, not to be unreasonably withheld. Then the prior consent can be given orally.
Okay.
But when it comes to the assignment, you've got to comply with the formalities.
Absolutely.
Yeah.
Any sensible commercial party would want the formal letter confirming that the consent has been given, that the assignment has been approved and registered in BNC's Register of Debts. But that is not the prior consent that's required for the purposes of Article 17C, as the judge found. So what the judge say, maybe I went over it too quickly, but I started there to try and show the court. The judge found that the prior consent was the email of 13th of June 2019. That email was subject to conditions subsequent, including the sending of the notice of assignment and other documents, and those conditions were satisfied. And at that point, everything that was required for Article 17C had been carried out. There is then a process of materialisation, inward facing, which is carried out. Documents are stamped and sent. But those subsequent steps are, in the judge's words, analytically irrelevant to the giving of prior consent in June 2019. So going back to paragraph 246 of the judgment, I was going through and I was explaining the judge's findings. The evidence did not say that any signatures were required for the consent in principle. The handbook did not say that any signatures were required for the consent in principle. And the judge next found that there was no other document or evidence which suggested that two signatures were ever required for the preliminary consent in principle. The judge concluded, in other words, that the prior consent given by Miss Marty by her email of the 13th of June 2019 did not need to be signed by two signatures. There was nothing to suggest that it needed to be signed by two signatures. And there was, therefore, no relevant qualification on how Miss Marty was to go about giving prior consent to an assignment, which was an act within the scope of her delegated authority. And
if that's what she found, it's very difficult to understand what she's saying with 321 then.
I was going to come to 321 because of the way it was put, but all of 321 is working on a basis. It addresses the second point as to whether a requirement, a consent to an assignment fell within the definition of banking operations within the meaning of the BNC rules. That's the second point.
But on your argument, that's irrelevant.
It is. And that's my submission, my lord.
But she doesn't say that.
Well, I'm going to come on to in a moment. Our submission, and the words I've got written down and was about to say, that the findings in paragraph 246 are a complete answer to BNC's case. As the judge noted, BNC's case on two signatures had in truth been directed to the later materialisation stage of the process, to the documents in November that were signed in November 2019, not the email that was sent in June 2019.
Can you just help me on this? She has a parenthesis and some and a quote, Mr. Lozano's mistake. I think I understand what that's referring to, but in case I haven't, what is that a reference to?
In his evidence, I think in his evidence, Mr. Lozano said he deliberately only signed with one signature because he would then be able to leverage the position as against CRF in the context of his assertion, unsupported.
That's in November.
In November, in the context of an assertion by him in his witness statement that he had been bribed, an allegation which was not pursued in London before the High Court. So it was evidence of Mr. Lozano that he'd deliberately, his mistake, his so-called mistake, wasn't a mistake. He deliberately signed with only one signature because then he knew CRF would have to come back to him and pay him his money. Now, that allegation of bribery, our submission was false. It was withdrawn. It plays no part in the decision. But we say that evidence is false, and he was cross-examined on it. But that's simply, the reference there is directed to what Mr. Lozano did in November 2019, nothing to do with the email in June 2019. Now, I'm conscious.
I think we've got a little bit more time. That clock is a little bit fast. Do carry on for a moment or two.
Certainly, thank you. I'm very grateful. So I've submitted that paragraph 246 was, and it remains, a complete answer to BNC's case. But it's not the only paragraph where the judge makes this point. The point, the judge returned to the point later in her judgment in paragraphs 331 to 335, which are on pages 148 to 149 of her judgment. So this is a section of the judgment where the judge addressed Mr. Lozano's subsequent correspondence of the 22nd and 25th of November. And in those paragraphs at 331, the judge observed that Mr. Lozano's email of the 22nd of November and his formal letter of the 25th of November 2019 were not in analytical terms relevant. But she nonetheless went on to consider what impact any arguments of Cuban law as to formalities had on those documents. And in that context, over the page, paragraph 322, the judge recorded that the reference to signatures within BNC's handbook, which it will be recalled outlines the process for consenting to the assignment of debts, comes after the point where a telex, email, SWIFT or fax is sent to the foreign party informing him that it is accepted in principle your request, that's the request to assign a debt, and that is after prior consent had been given. And at paragraph 333, she recorded that after the assigner and assignee had signed the assignment and sent it to BNC, the BNC handbook provides that at this point, the assignment is ready to be materialized. And she quotes the words, its materialization consists in sending both the assigner and the assignee a copy of the initial document duly signed by the Cuban side containing 2 authorized signatures of BNC. And at paragraph 334, the judge said that thus the only reference to signatures by the Cuban party appears after the assignment of documentation has been signed. That's after the assignment, yes, documentation has been signed. Forms no part of a process. It forms part of a process internal to BNC, the materialization of the assignment stage. It comes at a stage after the assigner and assignee have been given consent in principle. And that being the case, at paragraph 335, the judge said that even if there was a requirement for 2 signatures at this materialization stage, as BNC had submitted, it could not affect the validity of the 13th of June consent. The judge, in other words, again found that there was no requirement for signatures in connection with the giving of prior consent. There was no relevant qualification on how Miss Marty was to go about giving prior consent to an assignment within the scope of her delegated authority. And again, we say that is the complete answer to BNC's case. Now, I'm going to go on to consider paragraph 336, because again, it contains some important findings. But I note the time now, and I'll pause there if I may.
But how are you doing? I'm just thinking about timing tomorrow.
I'm doing quite well. I would like to have been slightly further on, but we will cut our cloth accordingly. So we will be fine.
As long as it's not inconvenient for anybody else, I think we should sit at 10:15 tomorrow. We'll do that. 10:15 tomorrow. Thank you.
Very grateful.